This is the Legal Eagle with an analysis of Heien versus North Carolina. To give you some background on the case, here are the facts. Officer Matt was following a suspicious vehicle and noticed that only one of the vehicle's brake lights was working, and therefore he pulled the driver over. While he was issuing a warning ticket for the broken brake light, Officer Matt became suspicious of the actions of the two occupants and their answers to his questions. Nicholas Heien, the car's owner, gave Officer Matt consent to search the vehicle. Officer Matt then found cocaine, and Heien was arrested and charged with attempted trafficking. At trial in the North Carolina State Court, the trial court denied Heien's motion to suppress the seized evidence on Fourth Amendment grounds, concluding that the vehicle's faulty brake light gave Officer Matt reasonable suspicion to initiate the stop. The Court of Appeals in North Carolina reversed, holding that the relevant code provision, which required that a car be equipped with a stop lamp, required only a single lamp, which Heien's vehicle had, and therefore the justification for the stop was objectively unreasonable. Reversing in turn, the state Supreme Court held that, even assuming no violation of the state law had occurred, Officer Matt's mistaken understanding of the law was reasonable, and thus the stop was valid. Heien was then granted a writ of certiorari by the United States Supreme Court. The Supreme Court of the United States addressed the following issue or issues in this case. Does a police officer's mistake of law provide the individualized, reasonable suspicion that the Fourth Amendment requires to justify a traffic stop? When making their determination for this case, the court used the following rule or rules. A mistake of law can give rise to the reasonable suspicion necessary to uphold a warrantless seizure under the Fourth Amendment. Now, to bring it all together. In this case, the court held that reasonable suspicion or probable cause are both justifications for a search under the meaning of the Fourth Amendment. The Fourth Amendment tolerates only reasonable mistakes, and those mistakes, whether of fact or of law, must be objectively reasonable. Courts do not examine the subjective understanding of the particular officer involved, and the inquiry is not as forgiving as the one employed in the distinct context of deciding whether an officer is entitled to qualified immunity for a constitutional or statutory violation. Thus, an officer can gain no Fourth Amendment advantage through a sloppy study of the laws he is duly bound to enforce. And now for my thoughts on the matter. Once again, this is another case that is classified under the passenger cases. And I think that this case, like the previous one I made a video about, is a little bit curious in that the officer's mistake of the law is justification for the search. Now, I would say in this case that the officer's belief about this law was objectively reasonable, and thus, in statute ambiguity cases such as this one, clarification through a legislative means is oftentimes the best way to do it, but in instances such as this, when the court is tasked with making this determination, sometimes you get weird rules and weird conclusions that say things like a mistake of law is justification for a search, and on face value that seems kind of odd, but by digging a little bit deeper, it makes a little bit more sense. Thank you so much for tuning into my video today. If you have any questions or comments, please leave them underneath, and I'll get back to you as soon as possible. Have a great day.